Good morning and welcome to the second episode of our new webinar series, Commercial Collections Corner, touching on all things commercial collections. Today's topic that I'm going to be talking about is deficiency collections after repo and sale of commercial equipment. My name is Andrew Voorhees. I'm an attorney and shareholder at Weltman, Weinberg & Reese, and I will be the moderator slash presenter of today's session. In my role, I'm responsible for giving you an overview of the collection process after your collateral has been repossessed and sold at sale. What are the best practices to ensure that you can get the closest you can to 100% recovery? I'm a commercial collections attorney at Weltman, Weinberg & Reese. I've been doing this for 20 years, and I can probably talk for hours and hours on this topic. I will do my best to get you an overview of this topic and hopefully lead to some discussion after the fact. That's some background on me. Now, before we get started, I would like to take a moment to go through a few housekeeping items. As a reminder, this is an interactive session, so please feel free to submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is also being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. I think you may already have a copy of the presentation slides in your possession. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars and hope you attend more in the future. So without further ado, let's get started with the presentation. So I'm here to talk to you about deficiency collections after repo and sale of commercial equipment. So what do I mean by commercial equipment? That could be agricultural equipment, it can be machinery, factory equipment, it can be trucks used in hauling, trucking over the state lines. We're not necessarily talking about personal vehicles, watercraft, motorcycles, things like that, but a lot of the principles apply there as well. So going into this webinar, and I'm on slide 2 for those that you're following along. Please type your questions in the questions feature to be answered during the presentation. I think I went over this. The webinar is being recorded, and a link to that recording will be sent to you following this webinar. And I already mentioned to you about the survey, so please share your feedback from today's session. So let's get started. If you're in the business of financing commercial equipment or any other collateral, you get into it with the best intentions. You know, the parties get into it not thinking that there's going to be a default, but if you're in the business long enough, a default will inevitably happen. So a collateral that you have repossessed and sold at auction rarely pays 100% of the balance due. And why is that? You know, there's a lot of variables that go into what the collateral will obtain at auction after it's repossessed. It could be the condition of the equipment. Your borrower may have left the equipment in bad shape, may not have kept up with repairs or maintenance. It's possible that the dealership that sold the equipment sold a lemon or a non-functioning piece of equipment that impacted its ability to realize the purpose it was purchased for. If you have a piece of agricultural equipment, depending on the time of year that it was sold, it may not get as high a price as some other time of year. So there's a lot of variables that go into it, but any of you in the business knows that once you repossess and sell equipment at auction, it's going for kind of a bargain basement price, and you're not going to typically get 100% of your balance due on the note or whatever instrument gave rise to the obligation in the first place. So what I'd like to talk to you about today is how to secure and enforce your rights to that deficiency balance to get to as close to 100% as possible. So after the equipment is sold, what can we do after that fact to recover even more of what is due after the fact? So going on to slide 4, to those of you that are following along, you know, enforcing your right to collect as much on a deficiency balance as possible begins at the original transaction stage. So what do I mean by that? Getting your documents in order at the beginning of the transaction is probably one of the most important things that you can do to ensure that down the road you can collect in the event of a default. So what are these documents that I'm referring to? So you need a security agreement. You need a signed agreement that evidences an intent by your borrower to grant a security interest in some piece of equipment or collateral. You need a financing statement to fill out and file with the state wherever you are to perfect your security interest, to let all others provide notice that you have a security interest in this particular equipment. You need a note or some other document with your borrower to evidence the obligation. What are they to pay over this period of time? What's the interest rate? What happens if they don't pay? What happens if they don't carry proper insurance? What happens if they file bankruptcy? All these need to be laid out in your document of indebtedness, the contract itself. And plus, in my opinion, in situations like this, transactions such as this, you want to have a guarantor. You want to have somebody personally obligated. If you're lending only to a business entity, an LLC or a corporation, it's very easy to close down those corporations and move on, even if you don't properly close them down with the state that they're incorporated in. If you have somebody personally liable as a guarantor in these documents, that really increases your chances to recover something down the road in the event of a default. That's much more difficult for an individual to vanish and alleviate themselves of the obligation if they're personally liable. So you need to get your documents in order. You need to make sure that they're signed in the proper spots, and you need to make sure that the documents comply to whatever state you're operating your business in. Now, the next prerequisite is to make sure you file your UCC financing statement, however your state requires that it be filed. You know, going back to pre-financial meltdown days prior to 2008, I had some clients early in my career that would get the proper documentation, would get their UCC financing statement, and would do everything right in the beginning, but at the end of the day, they just didn't file their financing statement. So when it came time to enforce their rights to that collateral, there had been a couple other creditors with a priority interest at that point because they just didn't follow through with filing of the paperwork. A lot of those problems have been corrected now since the financial crisis, but it's an unforced error that you want to protect yourself from. Get all the documentation and make sure that it's filed according to state law. Otherwise, you may not have any rights to the equipment at all, much like failing to affix a lien on a certificate of title for an automobile. If you don't follow through with the paperwork, you can lose any right to that vehicle and it could be transferred without your knowledge. So you want to make sure that that information makes it to the state. And third, and sometimes an often overlooked aspect of the original transaction that may not get enough press, but is really very important when you're looking down the line at collecting any deficiency balance, is to get all the proper information that you have on your customer. You know, a lot of this information can be gleaned from a credit application. You know, for example, a credit application will ask for the place of employment, bank information, location where the collateral is going to be kept, debt to income ratio, you know, and even such simple information as social security numbers, addresses, and phone numbers. You want to get this information at the beginning of the transaction because it will become invaluable down the road to collect on your deficiency balance. So even if your borrower is only a corporation, you want to know who's the owners of the corporation, who's the president, who's the CFO, where's their principal place of business located. All this demographic information that you can get on your borrower in the beginning will really help you down the road in the event of a default to collect on whatever judgment or deficiency that you have. So one of the questions that we had prior to our session today that I had a chance to take a look at, you know, there's a question regarding best practices for all business UCC collection. You know, this is different than a specific piece of collateral. You could file your UCC-1 with the state that lists a security interest in a certain piece of collateral, and here's a description, and here's a serial number. A lot of times, if your customer is a business, you have obtained a security interest in all business assets. And what does that mean? That means inventory, that means accounts receivable. It could mean the furniture and computers that are owned at the business location. That's what we call an all business asset security interest. So when filing your UCC as to an all business assets security interest, you know, all the laws under the UCC require is notice. You have to provide notice of what you have a security interest in. So simply saying, you know, inventory, accounts receivable in a general way is enough to provide that notice and perfect your security interest in those assets. You can provide more specific information if you wish. You know, for example, if your customer is a dentist's office or a chiropractor and they have equipment that may be very valuable if it is repossessed and sold down the road, you can list that specific equipment more descriptively in your UCC financing statement, but it's not required. But if you want to protect yourself a little more, you can do that. For example, you can list the specific equipment and include the words including but not limited to, and then include the language regarding all inventory, assets, furniture, etc. So moving on, and I'll talk more about the best practices for all business UCC collections as we go through the presentation here, but I wanted to make a point of talking about how that appears on the UCC financing statement. Now, for those of you following along, you know, we're looking at slide number 5, and we're still not to the deficiency stage, but it's important to talk about repossession as a default remedy. Obviously, if you have a perfected security interest in a piece of equipment, you have the right to repossess it after a default. What kinds of default would trigger such a right to repossess your equipment? Well, it depends on your specific contract, what type of default has occurred. So the most common is that they failed to make their timely payments. That is the most common type of default that would trigger your right to proceed against the equipment or any other remedies that the law provides. Other types of default that may be in your contract are a failure to maintain proper insurance, failure to maintain proper maintenance on the equipment, filing bankruptcy, dissolving the corporation. There's lots of ways that can be considered a technical default, but for the purposes of this talk going forward, I'm going to mention default as a failure to pay the balance due. So if you wish to repossess your equipment after a default, what are the ways that you can do that? And again, the ways to repossess equipment after a default, I could talk for hours on this subject, but for the limited amount of time that we have here, I'm going to kind of give you a high-level view of the most common ways to do that. In my experience, the best way to obtain your collateral after a default is to negotiate a voluntary repossession, reaching out to your customer and trying to work through what the issues are with payment. If there's some kind of issue with the equipment itself, or payments may be made up down the road, those are things that you can negotiate if you wish to maintain your relationship with the customer. However, if you're looking to obtain the collateral, try to get permission from the borrower to just come out and pick up the collateral. At this point, the borrower is saying, this is where it's located. I don't have any problem with you picking it up. Please come and pick it up, and I'll allow you to do that. That is the easiest way to do that. At that point, you can hire your representative to go out and repossess the collateral and begin the process of selling it at auction. But what happens if your customer is non-responsive or refuses to provide that kind of permission? A lot of times your customer just vanishes off the face of the earth when they stop paying. They stop taking your calls, so they stop answering your letters. Or they just say, forget it, I need the equipment to continue my business, or there's some other issue like the vendor sold me a bad piece of equipment and I want them to fix it, and you know, all sorts of different ways that that conversation can go. You are permitted legally to what I call undertake self-help repossession. That's you know, in your mind, the traditional thought of what a repossession is. You hire a repo company that goes out into the middle of the night and repos the vehicle or the equipment or what have you. You know, a lot of the repo situations you see in TV and movies, that's how it goes. But the law also states that you can't breach the peace, and breaching the peace is a very it's a very low standard. Breaching of the peace is any failure to provide permission to go onto property and repossess the equipment. So for example, you can see a truck or a piece of equipment in plain sight, but if you have to go on property where you're not permitted to go, that might be a breach of the peace. A breach of the peace is not permitted to complete the repo for obvious reasons. You don't want a repo of equipment to escalate into something that could lead to physical harm for the repo agent or the borrower. So if you get to that point where you can't get a voluntary repossession, you can't get onto the property to repossess it yourself, what's the legal process to obtain your equipment? That's called a replevin. So those of you that are unfamiliar with replevins, replevin is a separate court action, much like a complaint that you're filing with the court, seeking the court to give you an order to basically obtain your piece of equipment. So you have to file it much like a normal lawsuit. You have to serve it on the opposing party, and if granted, the opposing party is ordered to turn over that equipment to you as the lender. So depending on how much your borrower is going to fight the replevin will determine how long it goes. Many of them go to a default stage where your court basically says they haven't responded, they haven't answered or showed up at court in any way. So at this point, we're going to order them to return the equipment to you. But if they fight it and it has to go through a litigation process, it could be much longer. So those are the basic ways that you can get access to your collateral. Sometimes your borrower is absconded with the collateral, is moved it across state lines, and sometimes it may take a long time to find it. You know, in that unfortunate situation, you just have to follow through with the replevin process. So let's move into the meat and potatoes of the UCC in how you can preserve your right to collect a deficiency balance if your collateral does not obtain 100% of the balance due at auction. And for those of you following along, moving on to slide number 6, you have to preserve your right to the deficiency balance by following the specific requirements of the Uniform Commercial Code. And the UCC section 9-610, which has been adopted by most states, allows a creditor to dispose of secured collateral after a default. However, the disposition of the secured collateral must be commercially reasonable. And what do we mean by commercially reasonable? Because that's the most important aspect of the sale process. It means every aspect of a disposition of collateral, including the method, manner, time, place, and other terms, must be commercially reasonable. And time, method, and manner is most important. In the realm of commercial reasonableness, the UCC is more concerned with the process versus the outcome. And what do I mean by that? The UCC lays out a step-by-step process to dispose of your collateral in order for you to retain the right to collect a deficiency balance after the fact. It's not so concerned about the outcome, how much the collateral obtained at sale. In my experience, commercial reasonableness is probably the most asserted defense in lawsuits seeking to collect on a deficiency balance after sale. And one of the main arguments that a defendant would have in stating that the sale of the collateral was not commercially reasonable would be that it didn't obtain what they thought it should at auction. You know, it only obtained 20% of its claimed value, or a lot of times your borrower will come to court and say, hey, I know Joe Schmo down the street that would have bought this from me for much higher than you got at auction. That's not a defense, and that doesn't make a transaction commercially unreasonable just because you didn't receive the higher balance at a sale. It's more the UCC is more concerned about the process you went through to get that sale. And so let's talk about what's important to comply with the UCC. And so the first step is you need to send notice of the sale to your borrower. You need to send them a notice of sale and the opportunity to make the default right in a way, or to pay what's owed or come to some other arrangement. You need to send them notice, and you need to send notice in accordance with the UCC, and the section that requires that is UCC section 9-612, and that requires a notification of disposition sent after a default in 10 days or more from the earliest time of disposition set forth in the notification. So what does that mean? What does that legalese mean? You have to send timely notice to all the parties. And in a non-consumer goods transaction, a commercial transaction, much like what we're talking about now, the notification that you send to your borrower has to have certain inclusions to make them comply with the law. First, it has to describe the debtor and the secured party. It has to describe the collateral that is subject of the intended disposition. It has to state the method of the intended disposition. And that means, are you selling it at a public sale where the public is allowed to come into an auction house and bid on the equipment, or is it a private sale? Is it something, for example, on a certain list of auctioneers, or a certain list of possible buyers that's not generally open to the public? Both are fine, but you have to delineate which type you're using in the notice. You also have to provide notice that the debtor is entitled to an accounting of the unpaid indebtedness and states the change, if any, for an accounting. And you also have to state the time and place by identifying the place of the business or address by providing other information that in each case reasonably describes the location of a public disposition or the time after which any other disposition is to be made. So if you're providing notice of public disposition of your collateral, you have to provide the time and place where this is going to occur to provide the debtor to show up themselves and bid on the equipment if they wish. But at a private sale, you need to only provide notice of some date after which the sale is to occur. So it doesn't have to be specific as it is a private sale. UCC section 9-613 provides a good example of the form of this notice too, to send to your debtor. So the law provides just a step-by-step process and even an example of the proper notice to be sent to your debtor so that you can preserve your right to deficiency. So we've talked about the notice and its context, but do you have to actually prove that your debtor received the notice? That's not required under the UCC. You only need to send the notice so that it's reasonably meant to provide notice to your debtor. So sending to the best address that you have, regular and certified mail, would be good enough evidence that the notice was sent with, reasonably calculated to notify the debtor of the situation. So you don't need to provide evidence at court that they actually received the notice. So if you have to proceed with a lawsuit for a deficiency balance due, it's not necessary, and the debtor appears and says, well, I never got notice of this. I never knew about it. If I had known about it, I would have showed up and I would have bid the whole thing. You don't have, that's not a defense. They don't have to receive the notice, but you have to send the notice. So them not receiving the notice, even though it was sent, is not enough to make the sale commercially unreasonable at that point. We've already talked some about commercial reasonableness. We know that it's based on the time, method, and manner of the sale, and that it's conducted in a commercially reasonable manner. So what does the UCC say specifically that makes a sale commercially reasonable? And that can be found in UCC section 9-627. And this outlines specifically what would make a sale commercially reasonable. And that states a disposition of collateral is made in a commercially reasonable manner if the disposition is made, one, in the usual manner on any recognized market. So you want to make sure that you're selling the collateral as a a vehicle market or factory equipment market. You want to make sure that it's being sold to the right people. It has to be at the price current in any recognized market at the time of disposition, so it has to be appraised in the proper way by a licensed appraiser and listed for a price in accordance with that appraisal. If you do that, that's good enough. And it has to be in conformity with reasonable commercial practices among dealers of that type of property. And that again goes back to in a usual manner on a recognized market. So for example, selling a piece of agricultural equipment, you want to make sure that it's marketed and sold by a dealer of agricultural equipment. You don't want to send it to your local auto dealer or another auctioneer that has no experience in that type of equipment. You want to make sure that it's sold by a dealer that normally deals in that equipment. And once you go to court to collect your deficiency balance, you have to prove that this was done. You have to provide lists of bids, you have to provide the appraisal information, the vehicle condition information, if commercial reasonableness is disputed in some way. So again, if you follow the notice requirements, if you follow the commercial reasonableness requirements, that is enough to preserve your right to collect a deficiency balance after the fact, so long as you comply with the UCC. Again, you don't need to prove that you got the highest price you possibly could for the equipment. Any equipment that's being sold at auction is not going to obtain the highest price on a market. It's whoever's bidding on the equipment at that particular time. So there's no need to prove that you could have gotten more, or if you would have contacted the debtor's friend and like they wanted you to, and you don't have to go through that whole process. All you have to do is to follow what's specifically delineated in the UCC. So you've sent your notice, you've conducted your sale, hopefully in a commercial reasonable manner. What happens at the end? What kind of, is there another notice that you have to send at the end of that? So you have to send another notice after the sale of a deficiency or surplus. So this is another notice that you're sending to the debtor showing what was obtained for the equipment at auction, what was charged in fees, what was in charge in transport fees, and providing a number at the bottom line number that is your deficiency balance essentially. So you have to provide a notice under the UCC to your debtor that contains all these items, again, to preserve your right to enforce your right to a deficiency balance. So, and the contents of such notice can be found in UCC section 9-616, and that outlines what is to be included in the notice of deficiency or surplus. What is to be concluded? One, it states the amount of the surplus or deficiency. That is that calculation that shows what it costs to repossess and sell the item and what was gained at the sale. The net amount is your deficiency balance. And it provides an explanation in accordance with the UCC on how the secured party calculated that deficiency. Again, it's like a tax form kind of. It has what they obtained at auction minus the fees. The net amount is the deficiency. And it states what is due on the deficiency, and provides a telephone number or mailing address where information about the transaction can be made available to the debtor. So technically, there can be a surplus that would be on this form under UCC section 9-616, where there would be money due the borrower after the fact. It's rare. Obviously, I never see that in my profession, because if there's a surplus, there's really no need to protect your right to a deficiency. But sometimes there is a surplus, and those funds would have to be sent to the debtor after the fact, along with this notice indicating how the surplus was calculated. So that's the third brick in this in this structure to preserve your right to collateral after sale. So you need a notice of sale, You need to conduct the sale with commercial reasonableness, and you need a notice of deficiency or surplus. You need all these things in accordance with the UCC to be able to collect any deficiency after the fact. If you go to court and the court finds that you didn't comply with one of these, then you have no right to the deficiency under the clear terms of the UCC. So, assuming that you can enforce your deficiency balance by complying with the UCC, what happens then? How do you collect your deficiency balance? So, for example, say you have a piece of equipment that you provided financing for in the amount of $100,000. You sold it at auction. At the end of the day, the deficiency balance is, you sold it at the auction for $25,000, and the deficiency balance is somewhere around $75,000. It's still a substantial amount of the balance due that you need to collect from the debtor, even after repoing and selling the equipment. So how do you start to enforce that? How do you enforce your deficiency balance? So again, much like at the default stage, I think the most important thing to do is to reach out to your debtor after the sale of the collateral. See if you can work out this deficiency balance. See if you can negotiate a voluntary resolution to avoid having to go to court. Although you've sent notice of the deficiency, this is the path of least resistance. See what they can do to pay and alleviate the litigation process. And hopefully you're able to get a hold of them and negotiate something that's amicable for all parties. And this is where the information that you've obtained at the beginning of the transaction, the specific demographic information about your debtor, comes into play. So, for example, you have a $75,000 deficiency balance, and the debtor says, well, I really can't pay more than $20,000 more to resolve this. Well, how do we know if $20,000 is a decent offer or not? You have to go back and do your homework with the information that you had before. You have to look at where they're working. How much are they being paid? Are they working? Are they disabled in some way? Are they on government assistance? What is their asset position? A lot of that information, you have the start of that at the beginning of the transaction, the demographic information on your debtor. So that's good information to, one, determine whether any offer that they're making to you in a pre-suit process would be good to resolve the deficiency balance. But moving on to what happens if, again, you're not getting a response from your debtor, or you're getting a response that you don't like. Whether that's, I don't have any money and I can't possibly pay this, to I don't agree with the way that you sold the equipment, I'm not paying this, to, basically F off, I'm not paying this. So if you get a situation like that, then you have to make the decision on whether you want to sue on your deficiency balance. And that moves us to the litigation stage. So when moving to the litigation stage, you have to, again, think long and hard about whether it's worth it to go through that. Again, doing your homework on your debtor, it's determining what their asset position is, determining if they own property anywhere, determining whether you're going to be able to collect this deficiency balance should you get a judgment. So that's a big decision to make, because once you're in litigation, sometimes you can't get out depending on what happens. But sometimes that's the only way to collect on these sizable deficiency balances. Now, I could talk for hours and hours and hours on litigation and the litigation process. We just don't have the time to go through all that today. Hopefully you'll attend one of our other webinars on the litigation process somewhere down the line. But just really briefly on the litigation process, you've obtained your deficiency. You have a deficiency balance that you want to obtain a judgment on because you're not getting any cooperation from your debtor. So you have to file a lawsuit in the appropriate jurisdiction. You're filing a lawsuit on your original paperwork, your original note. So you want to include your note, any personal guarantee, and your balance evidence will be that deficiency statement that you had already sent out that shows what's due after the sale. So litigation can resolve itself in 30 to 60 days via a default judgment, or it can go for years depending on how how much your debtor wants to fight it. So there's a lot of factors to consider whether going the litigation route is good and worth it. But if you're not getting a voluntary response to paying that deficiency balance, that's where you have to go. Now, if you go through the litigation process, obviously the best result is a negotiated settlement that everyone can live with. But assuming that you have to go all the way to through trial, or you get a default judgment, you get your judgment. So at that point, your deficiency balance has been converted into a court judgment. So what does that mean? A judgment's really a piece of paper from the court saying that, yeah, you're right, you're owed this money and they have to pay it. But that's where the help that the court gives you in the litigation process ends. The court's not going to collect your judgment for you. You're on your own with that, or through your attorney like me. But once you get the judgment, which says that, yes, you have the right to collect this deficiency balance from your debtor, it's no longer a deficiency balance at that point, it's a judgment balance, which provides you with all the legal remedies available to involuntarily collect on that judgment. So for those of you following along, how do you collect on your judgment? And there's lots of remedies that are available to you to collect on your judgment. A lot of them are state specific. What will work in one state will not work in another. There's exemptions that can be raised, but you know, I'm here and we're here at Weltman to help you navigate through that process. So for those of you following along, we're on slide 8. You know, the post-judgment remedies available. These are some of the more common ones. Like I said before, some states allow them, some states do not. But I'd like to go through these and so you can at least see what is available to you to collect on this deficiency balance once it's been converted to a legal judgment. So again, when collecting your judgment, the information that you've obtained on your debtor at the beginning of the transaction definitely comes into play again here. That information can be used to involuntarily collect your deficiency balance from your debtor. So looking at the items that I have here, many courts allow judgment debtors exams or in the alternative post-judgment depositions. These are a good way to supplement the information that you obtained at the beginning of the transaction to collect on your debtor. How this process typically works is that you file an execution with the court, and the court sends out a notice that's served typically by sheriff or bailiff service, but sometimes you can utilize a process server to serve upon the defendant a notice to appear from court, an order from the court to appear, and answer questions about their asset position. So how this would work is you would go to court, the judgment debtor would be sworn in by the court officer, and you would be free to question them on their assets and ability to pay this judgment. You could ask them about their bank accounts and balances contained therein. You can ask them about their home, how much property that they own, their vehicles, whether they have life insurance, whether they're obligated to pay any spousal or child support, whether receiving any support from the government, where they work, how much they make. all that's fair game in a judgment debtor's exam. So this is the best way to get the information to supplement the original demographic information that you got in the beginning to give yourself a profile on how best to collect on your debtor. At the same time, I'm filing a judgment debtor's exam if needed. I'm also filing a judgment lien. So some states allow judgment liens to be filed on pieces of property. So for example, here in Ohio, if I obtain a judgment, I can file a judgment lien in the county where I believe the defendant has property, where they own property, whether it be residential or commercial property. And that lien will show up on title reports and attach to that piece of property or any property located in that county. It doesn't have to be in Ohio anyway. It doesn't have to be on a specific piece of property. You just have to file it with the county clerk of courts that you have a judgment lien in that particular county, and it will attach to any properties that that defendant owns in that property. Now, judgment liens technically give you an interest in a debtor's property, but if you want to attempt a foreclosure on your judgment lien, that's typically not advisable. If you want to proceed with a foreclosure in Ohio, there's a fairly sizable homestead exemption that would make proceeding on a foreclosure for a judgment lien not worth it. I believe it's up to $125,000 that is exempt from a judgment creditor in a personal residence. Some states, like Florida, don't allow a judgment lien to attach to any personal residence. So the effectiveness of judgment liens really depends on the state that you're in. But if your state does allow judgment liens, then they can be used to get your judgment paid down the road. For example, your debtor wants to sell their property, your judgment lien is going to show up in the title report, and it has to be dealt with before the property can be transferred with clear title. At that point, it typically leads to a negotiation or hopefully full payoff of your judgment lien. So it's something that you want to file that's not going to help you probably immediately, but maybe 5, 10, maybe even 20 years down the line, if you keep renewing it, that can get a payoff for you at the end of the day. Moving on, wage garnishments, again, state specific. Some states allow them, some states don't. In Ohio here, where I am located, we have them. And a wage garnishment will attach, here in Ohio, 25% of the net income of your judgment debtor. So that's the amount after taxes. So if you do have a good place of employment information, whether obtained from your original demographic information from the transaction, or you conducted a debtor's exam and found out this information, you can file another execution from the court, and the court will order their employer to withhold 25% of their net earnings to be paid into the court, and assuming there isn't an allowable exemption claimed, those funds will be turned over to you or your attorney. So wage garnishments continue until the balance is paid off, or the debtor is no longer employed. Some drawbacks to the wage garnishments are that child support garnishments or spousal support garnishments always take priority. So you may be behind them in getting paid. So if one of those is going on, your wage garnishment is going to be pushed to the back of the line. Also, if your debtor is having problems paying the bills owed to you, they might be having problem paying bills to others. So you may have an already pre-existing wage garnishment that you would be stacked behind and have to wait again until that garnishment has resolved itself. So, but wage garnishments are continuing. If you file one successfully, you can be assured every 2 weeks or 1 week or however often the debtor is paid, those funds will be paid into the court and eventually released to you, and that'll be at least be some sort of an income stream on your deficiency judgment. The next Tax refund garnishments, we don't offer those in Ohio. They're not legal in Ohio. I know in Michigan they're legal, but at a certain time of year you can garnish tax refunds for your debtor. So some states do allow that. Again, if your debtor is getting a tax refund, that is a good way to get a chunk of money to pay down your judgment as well. Bank attachments are one of the first things that you should employ if you have the proper information. Again, this is why it's so important to get that demographic information at the beginning of the transaction. If you know where they're doing their banking, then you know where to file a bank attachment after you obtain a judgment. Again, this is a execution filed with the court where the court is ordering a certain bank to freeze any funds that's being held by your judgment debtor. Again, they're subject to exemptions. Funds that are being deposited into a bank account that are from the government, like disability, Social Security, those cannot be attached. Funds going in for pension payments, any kind of retirement, those are exempt. There's a whole list of exemptions in the Ohio Revised Code, and I'm sure other codes around the country that allow a debtor to show up and say, hey, these funds are exempt that have been attached. They have to be given back to me. But the bank will freeze those funds pending any hearing on the exemptions. So this is more, instead of wage garnishments are continuing, where you file one and it's just a steady stream so long as the debtor's employed there. Bank attachments are more of a snapshot. You file a bank attachment that attaches any funds that are within the bank account at that period of time. If you want to do another one, then you have to file another one. But those are invaluable, and typically one of the first things that I do once I obtain a judgment, if I have that bank account information. You can get a good chunk of your funds that are due on a deficiency judgment from a bank attachment. So I think those are invaluable. Moving on, property levies. So property levies, you have to employ them cautiously, but this is much like asserting your interest in a piece of collateral. So a property levy is where you file an execution with the court seeking to have a sheriff go out and tag a certain item of the debtors to be possessed and sold at auction. So, for example, again, using your demographic information, doing your homework, information you got from debtor's exams, say your debtor has a classic car and it has some value to it. You can file an execution with the court that would, again, have a sheriff go out and tag that item for eventual auction. And again, it would be, you would, as the judgment creditor, you would be responsible for paying the costs of that, of having the vehicle transported, stored, sold at auction. But again, at the end of the day, you'd be entitled to any funds that property would be able to obtain at auction. So, you know, you can file them against somebody's household goods. I don't normally recommend that unless you're really certain that they have appliances and things that are worth it, because as you know, repossessing items and storing them and selling them at auction and paying all the fees and the sheriff's fees, that can get quite expensive, and you want to be absolutely sure that if you do file a property levy, whatever property you're having the sheriff go out and tag for sale is going to be worth it in the long run. So you want to look at things like jewelry, art, fine art. You want to look at vehicles that are not encumbered by an existing lien on a certificate of title. You want to look at equipment and tools that are in good condition. Those are the things that you want to get at a debtor's exam to determine whether a property levy is worth it. And the last thing I want to touch on are creditors' bills and other equitable relief. These are complicated processes that require a lot of conformance with local law, and basically what you're trying to do with these are you're saying that perhaps your debtor is not getting regular wages, or he or she is a commissioned salesperson and they don't get a regular wage that would be subject to a wage garnishment. In that instance, you go to the court and seek equitable relief, which means that you're seeking an order from the court as opposed to a monetary judgment. You're asking the court to direct any income stream that's owed to your judgment debtor to be directed towards you. So for example, you have a commissioned salesperson that their only income through their work is commission sales. It's not a regular wage. At that point, you'd have to file another lawsuit against not only your judgment debtor, but you'd have to file it against whatever party owes your judgment debtor funds, and you would sue them to have an order from the court directing this third party to pay you instead of your judgment debtor. Typically, something like this is a vehicle of last resort in collecting your judgment, but it has been known to be effective so long as you follow whatever state-specific rules that are required. But summarizing these remedies available to collect your judgment, again, every step of this process, from the very beginning where there's a default, to the repo, to the collection of the deficiency balance, to filing a lawsuit on that deficiency, to collecting your judgment. In my mind, every step along the way is meant to elicit some kind of positive resolution. It's important to be open to resolving these things amicably, because the cost of doing anything through the courts can be rather high. So if you can, for example, file a lawsuit and get a settlement that you're comfortable with, that might be the best resolution, as opposed to litigating a case for a year and a half. Or, for example, you file a wage garnishment and you might be getting an income stream from that, but if you file a wage garnishment and it prompts an overture of resolution from your debtor, then maybe the resolution might be better than just waiting for the wage garnishment to run its course. So my advice in that is be open to these types of settlement resolutions, because sometimes that's the best course than chasing your debtor around for forever sometimes. Moving on to questions. I know we only have a couple minutes left. I did receive some questions ahead of time. I'll do my best to answer them here. There was a question about all business assets security interest UCC collection. So we talked earlier about collecting or security interests on all the business assets. When you file a financing statement that lists, inventory, equipment, everything in a non-specific way, that would be a security interest in all business assets. Again, a lot of it applies to what I spoke about property levies. If you're going to assert your security interest in all business assets, you want to make sure that it's worth it. You want to make sure that there isn't another creditor that has purchase money security interest on certain property, that there isn't another creditor with a higher priority financing statement. You want to make sure that none of those conditions exist before you move forward with foreclosing on all business assets that you have a security interest in. So again, that requires doing a lot of homework to ensure that you're not just throwing money away doing an auction where a higher priority creditor would obtain those proceeds. So you want to go through something like that with your eyes wide open, but sometimes it's worth it depending on the lucrative nature of the business. I know there was a question about how do you get around not having a signed contract to assert your security interest. There's really no way to do that. You need a signed contract to have a security interest in a piece of collateral. So you need something evidencing a grant of a security interest in a piece of collateral. So without a signed contract, I really don't think there's a way to affix a security interest on a piece of collateral. You really need those signed writings. So I know we're running out of time. If there's any questions that anybody has, I'll be happy to answer them outside of this proceeding. Please feel free to contact me. I'd be happy to answer any questions that you have. My information is contained on the slides that were provided to you. I hope you found this presentation informative. Just as a reminder, a short survey will pop up on your screen when this webinar ends. Please feel free to share your feedback and let us know what future webinar topics you'd like to see. I would like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. So anything that I've talked about that you'd like to expand on, I'm sure we have a webinar topic about that. We offer information on topics such as collateral recovery, real estate, bankruptcy, just to name a few. We can send you a link to the library in the follow-up email. Thank you again for attending, and have a great rest of your day. Thank you very much.